Got a question asking if a property manager can tow a tenant's vehicle if it's not inside their garage. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, that question is going to depend on who has the rightful possession of the property outside of this garage, okay? So, for example, a single-family residence. When you rent out a single-family residence, you usually get the yards, and it includes like the driveway and front and backyard here. So I actually had a case one time several years ago. A property manager decided to tow a tenant's vehicle off a single-family lot. That was a big no-no, because the property manager or landlord doesn't have possession of the driveway. However, it is very common in apartment complexes or condo buildings that side to deal with an HOA that the apartment owner, the landlord basically, or the HOA is actually responsible for maintaining the roads and the parking lot and so forth. So in that case, if a tenant parks illegally or blocks in another unit or space or parks in a fire lane, a lot of times the landlord, if they have the appropriate signage, usually it's in the front of the apartment complex saying, hey, unauthorized parked vehicles are subject to tow. Or if you're given a citation under the vehicle code for parking, illegally or in an unauthorized way under the vehicle code, your car could be subject to tow by the landlord or the property management company. So it really just depends on context. Usually the best policy for a lot of landlords, I tell, especially if you have like an apartment complex or something where, hey, there's shared parking and so forth, or, tenants need to park their cars properly and they're not parking abandoned vehicles and so forth, is not only have the signage as required by the vehicle code, but specify in the lease how the number of slots a tenant is authorized or is basically gets with the unit. So if a unit gets one parking space, that should be specified in the lease, and if it's assigned parking, that should be specified as well too. You should have terms in the lease that say that the tenants at all times need to park their cars properly, and they can't park abandoned vehicles and have keep hazards or oversized vehicles like RVs and boats and so forth on the property. Because if you do have a lease term like that and parking specified and your tenant's violating that, not only are they subject to possible tow, you could also give them a 3-day notice to perform, warning them, hey, listen, you are violating the parking provisions in your lease agreement. It's a material term. We need you to, cease and desist the unlawful parking, or you need to remove that abandoned vehicle from the parking lot, because again, that could be used for the basis of an eviction. And there's good reason for that, because in a lot of cities and counties, having abandoned vehicles is considered like a public nuisance, and landlords can get cited for that, for various things like that. So you want to make sure you have all remedies under the law basically at your disposal to address a problematic problem like that. So folks, if you're in the Northern California area and if you're a landlord and you need help dealing with a problematic tenant situation, or what you need to know if you can tow a vehicle or not, or should you use a 3-day notice to perform, you're in the Northern California area, feel free to reach out to our profile below. It goes to our website. You can book a free case review there. Just a couple questions to see if we're going to be a good fit or not. We'll go from there. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.